How does alimony actually work in a Florida divorce? I'm Adam B. Cordover, a collaborative divorce attorney here in Tampa Bay. At its core, alimony in Florida comes down to two questions. Does one spouse have a need for support, and does the other spouse have the ability to pay? Need means this. Can your spouse cover their own reasonable monthly expenses with their own income? If the answer is no, then your spouse likely has a need for alimony. Ability to pay then looks at you. Can you cover your own expenses and still have money left over to help cover your spouse's expenses? If yes, then it sounds like you have the ability to pay. Once both need and ability to pay are determined, Florida law looks at different factors, including the standard of living during the marriage, the contributions each of you made, both financially and non-financially, any career or educational sacrifices, and each person's ability to earn income going forward. One thing to know is that there are now statutory limits on alimony. These are not guidelines that tell you how much alimony you will have to pay or you will receive, but rather the maximums that a court could order in duration and amount. For duration, we generally look at the length of the marriage. For marriages that last less than 10 years, support can last up to 50% of the length of the marriage. For marriages between 10 to 20 years, alimony can last up to 60% of the length of the marriage. And for marriages of 20 years or more, alimony can last up to 75% of the length of the marriage. As for the amount, a court typically cannot order more than 35% of the difference between your income and your spouse's income, and no more than the receiving spouse's actual need. Another important concept is imputation of income. If you or your spouse are not working, the court may ask, what could you reasonably be earning using your best efforts? Oftentimes there's a look back at what each spouse has earned over the last 5 years, and even if a spouse has not worked in more than 5 years, for purposes of calculating the alimony maximums, it's generally assumed that the spouse can be earning some amount to help support themselves. Courts also look at all sources of income, not just salary. That can include investment income and sometimes even expected returns from retirement accounts. Here is where people oftentimes get confused. These rules are not guarantees, they are guardrails. Real outcomes depend heavily on the specific facts of your situation. In traditional divorce, these decisions are made by a judge, oftentimes after a long and public process, and the results may feel very rigid. On the other hand, in a collaborative divorce, you and your spouse can create a more customized solution. You both will have your own separate lawyers to give you each independent legal advice, but your collaborative lawyers are restrained from spinning things out of control by taking things into the adversarial court system. This way you can structure support in a way that fits your real life, whether that means stepping down payments over time, tying support to specific goals, or coordinating it with the division of assets. It gives you more control and keeps many of your sensitive financial details private. You don't have to figure this out on your own. In fact, we invite you to schedule a virtual planning meeting by calling us at 813-443-0615 or visiting our website at familydiplomacy.com. We work with clients in every county in Florida with offices available by appointment in Tampa, St. Petersburg, and Sarasota. When discretion matters, count on us.